Good morning.
Good morning.
Good morning.
Lords, I appear for the Secretary of State this morning, who is the appellant in these proceedings. My learned friend, Ms. Leringan, appears for the respondent.
Yes. Right.
My Lords, this case is about a Turkish national, KD, who arrived in the UK unlawfully and made what a judge described was a wholly fraudulent claim with no truthful foundation. Despite the refusal of his asylum claim and dismissal of subsequent appeal, he continued to reside here unlawfully and committed a crime of utmost seriousness. He murdered his 23-year-old wife out of jealousy by multiple stabbings. The Secretary of State, unsurprisingly, served him with a deportation notice on the basis that he had murdered his wife. He responded by saying that he could not be deported precisely for that reason. He claimed that he would be at risk in Turkey because he had murdered his wife and the wife's family would seek revenge. He also claimed that he was a supporter of DHKPC, which is a terrorist organization, and that Turkish authorities would persecute him because of his imputed political opinion and would provide him no protection.
I think I've read it, but what's the status of that organization in this country?
It is a terrorist.
It's a prescribed organization.
Yes, it is. Judge Scott in the First-Tier Tribunal allowed KD's fresh asylum appeal. In doing so, the judge held that he was not a danger to the community of the UK and would be at risk of persecution in Turkey. In arriving at that conclusion, the judge departed from the judicial findings made in KD's original asylum appeal. Judge Perkins at the Upper Tribunal upheld Judge Scott's decision, holding that it was free from any legal error, and this, as the court knows, is an appeal from that decision. Lords, there are 4 grounds of appeal. The first ground concerns the delay on part of Judge Perkins in promulgating his decision. There was a delay of 12 months, around 12 months, between the date of the hearing and the date of the decision, and the ground is that the delay renders the decision unsafe. The second ground concerns exclusion from the United Kingdom from the Refugee Convention and Judge Scott's finding that KD is not a threat to the community. The ground, my lords, is that Judge Scott's approach to Section 72 was legally flawed and her findings were inadequately reasoned and perverse. Grounds 3 and 4, my lords, concern an overlapping issue as to the effect of the judicial findings made in KD's original asylum appeal. Ground 3 is that Judge Scott misdirected herself in law and misapplied the authority in departing from the previous judicial findings, whereas ground 4 is that Judge Scott's approach to the documentary evidence was flawed.
Well, are they, I mean, could you in another life have drafted that as a single ground of appeal?
Yes.
I mean, in a sense, the document point
Yes.
is part of the Diva-Sealand point, isn't it?
Absolutely. So what I'm subject to any observations, what I propose to do this morning is to address you first on grounds 2, 3, and 4, the grounds that are directed to Judge Scott's decision. And in order to save the court's time and to avoid duplication, I will deal with grounds 3 and 4 together.
Thank you. Well, can I, in order to save potentially your time, say that I know that our collective view is that it's 2, 3, and 4 that we're really here for.
Absolutely.
I appreciate you've got a ground in relation to delay, but it's not going to get you very far on its own. And so by all means say anything you want to about that at the end, but we're really interested in the other grounds.
Absolutely. So if my lords, you are with me on grounds 2, 3, and 4, you will allow the appeal. If you're not with me on those grounds, in all likelihood, you will dismiss the appeal. But I will address you on ground 4 very briefly at the end, and we'll
By all means, we're not shutting you out. We're just trying to get a bit of light and shade.
Absolutely. But, my Lord, I will explain in due course why is it that the Secretary of State felt it appropriate to make that point. So I'll start, therefore, with ground 2, the ground that concerns exclusion from the Refugee Convention and Section 72. In my respectful submission, the law that is relevant to this ground is set out in this court's judgment in EN Serbia. In the authorities bundle,
it's page 57.
Very grateful. Behind tab 4. If you look at page 68 of the bundle, you'll see paragraph 6 of the judgment of Lord Justice Stanley Burnton. His Lordship identified the relevant provisions. My Lords know that Article 1 of the Refugee Convention defines the term refugee, and Article 33 concerns prohibition on expulsion and return. You have that at page 69 of the bundle. The contracting states are obliged not to return a refugee, but there is an exception to that principle in Article 33(2). And the exception concerns a refugee in respect of whom there are reasonable grounds for regarding them as a danger to the society of the country in which he is or who, having been convicted of a final judgment of a particularly serious crime, constitutes a danger to the community of that country. So that is the underlying provision. The domestic provision that gives effect to that provision in the Refugee Convention and provides further clarification is Section 72 of the 2002 Act. And you have that at paragraph 7 of that judgment. My Lords will see that subsection 2 provides that there is a presumption that a person who has been convicted of a final judgment of a particularly serious crime and to constitute a danger to the community of the UK in the circumstances where he has been convicted of an offence and the sentence is at least 2 years. Of course, a sentence of life imprisonment exceeds greatly from that threshold, and there is no question that murder is a particularly serious crime. The presumption is rebuttable. This is subsection 6. And the judgment then reconciles earlier authorities on the subject. There are two particular paragraphs that I would respectfully invite my Lords to look at. The first is paragraph 45. You have that paragraph at page 79 of the bundle. Lord Justice Stanley Burnton said in that paragraph that the words particularly serious crime are clear. That no one questions the fact that murder is a particularly serious crime. So far as danger to the community is concerned, this is the point in the appeal, the danger must be real. But if a person is convicted of a particularly serious crime and there is a real risk of its repetition, he is likely to constitute a danger to the community. Real risk is the phrase that I would respectfully invite my Lords to highlight. A real risk, not a significant risk or a medium risk, a real risk. And there is, in my respectful submission, a good reason why the court felt it appropriate to use that phrase. And if you look at paragraph 46, you'll see that the word risk again appears. I would accept that normally danger is demonstrated by proof of the particularly serious crime and the risk of its recurrence. a real risk. So where there is a medium or low risk of reoffending or harm, that could in principle constitute a real risk. Now take example, my lords, of a person who has committed a very serious crime, say murder, and has been sentenced to life imprisonment. He spends 15 years in prison. Now during that period, his risk of reoffending and harm is reduced automatically because he is in controlled environment, he is in prison. Once he is released on license, the parole board, the probation is satisfied that his risks could be managed in community. If there is a significant risk of reoffending and harm, in all likelihood that person would not be released. The Secretary of State, of course, makes deportation decisions in cases where someone is presently in custody or someone who has recently been released. The point, my lords, is that there is a difference between existence of risk and management of that risk in community. When the parole board or probation makes an assessment, their assessment, in my submission, is focused on the management of the risk in community. But the Secretary of State and the judicial decision maker in asylum cases, they address a different question. Not that whether there is a high risk of reoffending or whether risk can be managed in community, but simply whether the risk exists, whether there is a real risk, a risk that is more than fanciful.
What is the test that the parole board apply in relation to whether or not somebody is suitable for release? I mean, I'm sorry to put you on the spot. Maybe you don't know, but you're drawing attention to a difference between how the parole board might operate and how Section 72 might operate. And it just seems to me it might be helpful to have an understanding if you're making that submission as to where you submit the bars are drawn in the individual cases.
Yes, Lord, I have a sort of vague recollection of the test, but I do not wish to say something.
I don't think that would be authoritative.
No. But I will answer that question with your permission in due course once I have the opportunity to check it precisely what the test is. But the submission that I do make is that the question for the decision maker in this context concerns the existence of risk, whether there is a real risk. So this is, my lords, EN. The only other authority that I will...
Well, there's also, just before we leave EN, I was just looking at the paragraphs through to 47.
Yes.
So whilst in paragraph 46, the reference is to risk of recurrence or the recurrence of a similar offence, actually the offence doesn't even have to be similar.
Of course, yes.
In paragraph 47, instances are given, and in particular that the risk to community does not have to be a physical risk.
Absolutely.
It can be a risk of whatever kind. The other factor that seems to me is bound to be relevant when one's considering risk assessment is not just the likelihood of recurrence, but also the gravity of the consequences if it did recur.
Yes.
I mean, in other words, if somebody's going to shoplift more than once, well, that's one situation. If somebody's going to kill somebody more than once, that's another.
Of course, yes, yeah. Yes, and of course you'll hear more submissions on this once when I show you the reasoning of the tribunal.
Well, yes, I mean where it was said it hasn't recurred.
Yes. So yes. The point essentially is that he's only committed one murder.
Right.
One murder, of course, is too much. So this is EN. The only other authority that will assist you is MA Pakistan as to as to the relation between an assessment made by the probation and the assessment made by judicial decision makers in this context. So MA is behind tab 5 of the authorities bundle. A deportation case which raised issues as to whether MA was a danger to the community. And may I respectfully take you to paragraph 19 of that judgment. And this is where the court identified what, in my respectful submission, is a relevant consideration, a consideration to which the decision maker must draw attention to in making decisions. My lords will see that in that case, the tribunal arrived at a different conclusion, that there was a danger to the community for two reasons. The first is gravity of the offense, and second is that MA was in denial. He was in denial. He had not accepted guilt and maintained that he was innocent. So lack of remorse, lack of acceptance of guilt is a relevant consideration. If you look at the concluding part of this paragraph, which is on the next page.
Sorry, I was just,
Yes.
this was a drug trafficker.
Yes.
And a money launderer.
Yes.
That was the offending.
Of course, yes.
And he received a sentence of 3 years.
Yes. So the judge, in that case, held that he, despite that sentence, was, in light of that sentence, he was a danger to the community for two reasons. The offense was quite serious, and second, he had not accepted guilt. And if you look at the concluding part of that particular paragraph, you'll see that the court held that the judge in that case was entitled to put more weight than the probation officer would to the fact that the applicant had never accepted his guilt. And more importantly, what may be an assessment of low risk for the purpose of criminal sentencing is not necessarily to be considered a low risk when looking at the future behavior of this particular applicant. A risk of 17% reoffending over a 2-year period is not, in the context of a deportation matter, in the context of deportation, a matter which can be treated as insignificant. So the point is that probation, when they are forming a view as to whether the risk can be managed in community, or exercising an altogether different function. And if they consider the risk to be low, that does not necessarily mean that there is no real risk of, there is no real risk. Now, with these two authorities in mind, may I then respectfully show you, firstly, the sentencing remarks, and then the reasoning of Judge Scott. The sentencing remarks are at page 126 of the bundle. They are quite brief, but what one gets from them, this is the middle of paragraph 127, is that the offending entailed very considerable violence. KD took life of his wife in the circumstances of very considerable violence.
It doesn't appear, I think, from what we've read, what the nature of the defence was.
No.
I mean, it was a jury verdict after a trial.
It was, yes.
There's reference to provocation in the first paragraph, although not amounting to defence in law. So
The inference may be that that was that was what it was about.
Yes.
Right. Well, it doesn't greatly matter, but just so we understand
No.
as best we can the framework.
So these are the sentencing remarks, and if you then look at the judge's decision, this is the decision of Judge Scott, page 76 of the bundle. And the judge's findings as to section 72 are at page 83 to 85. 83, the judge accepts quite properly that KD has committed a particularly serious crime. The judge then considers whether he constitutes a danger to the community, refers to EN, but in my respectful submission, failed to apply EN in substance. Now, if you look at paragraph 34, this is where the real reasoning commence. You'll see that the judge there relied on a letter written by Mr. Mayor of the probation service, and that letter stated that KD is assessed as posing a medium risk of harm to future partners based on his offending. Medium risk of harm to future partners. Risk of reoffending is low, and the letter then concludes, and what is quoted in my respectful submission is relevant. The letter did not say that KD has integrated in the community. The letter said, in effect, that KD is expected to integrate within community in future with assistance of the offender's manager.
It may be clear to you, but it isn't yet clear to me. The previous sentences, the first one which begins, the appellant is assessed, and so forth, and the second one beginning, however, how do those two fit together?
Well, risk of harm to future partners is medium, risk of reoffending is low.
Sorry, what's the distinction? Harm to partners that fall short of reoffending?
Yes. So, well,
that's a very powerful crystal ball.
Do we have this letter?
We don't have this letter, but we can provide that fairly swiftly.
Because that may clarify, my Lord Justice.
Well, I wondered whether it's something is to do with, one is to do with the type of harm, and one is to do with the likelihood of it occurring.
Well, it could be, having read these sorts of documents before, it could be that actually the second observation is in relation to offending generally.
Yes.
So the first observation is, and I'm not saying this is what it says because I haven't seen the letter. First observation is, what's the risk to a future partner because of the particular circumstances of the index offence? And then the second observation is, what's the risk of committing any
general offence?
Yes, any offence.
Well, Lord, we will of course provide that letter to you. But whenever there is an assessment by the probation, in my experience, there is always the assessment is always in this manner. There is always an assessment of risk of harm and a separate assessment of risk of reoffending. I don't know precisely
Well,
why.
one can quite see that it might be different. So, in other words, for example, if it's a person who is habitually law-abiding but has committed some terrible offence in circumstances of this kind, then I can quite see one might consider, on the one hand, the likelihood of a repetition of something similar. On the other hand, how likely they are to start on a new criminal path of a different kind. Right. So that's one potential as my lord has said, consequence. But anyhow, it doesn't really matter for your appeal.
Yes. So
because you say that whether he's a medium risk of harm and whether it's subsequently recalibrated to a low risk of harm to intimate partners doesn't make any difference from your point of view.
because no matter how one looks at it, there
It's
is
a
no
it's a
doubt
real risk of
real
harm.
risk. Precisely. So the judge hasn't really addressed her mind whether the risk is a real risk. A medium risk of harm surely entails a real risk, no matter how one looks at it. So there is, in that paragraph in my submission, a failure to apply EN in substance.
Right, so just while we're making lists, you're going to do your best, please, to provide us with the probation letter and also
Yes.
to give us some information as to how this risk assessment works
Yes, absolutely.
in general.
Paragraph 35, I find that the appellant's remorse is relevant. Now this, in my submission, is a perverse finding. It had no evidential basis whatsoever. You do not have underlying evidence before you, but nowhere in his evidence KD ever expressed remorse for his crime. All he did was express a regret for what had happened. He expressed that regret to the information that he provided to the parole board, which is referred at the end of that paragraph. There is, in my respective submission, a fundamental difference between expressing regret and being remorseful. Regret is feeling of sadness or disappointment or wishing things had been different. Remorse, on the other hand, is acceptance of guilt, taking responsibility, and a desire to make amends. Nowhere in the evidence that the judge has cited KD ever accepted responsibility for the crime or accepted his guilt or expressed a desire to make amends. And therefore that finding, which in my submission is plainly material to the outcome, is not justified. The judge took that as a relevant consideration in the circumstances where there was no expression of remorse. Paragraph 38, the judge gives 4 reasons for finding that presumption has been rebutted. The first reason in my submission is quite remarkable, namely that the appellant has committed just one murder. He only has conviction for one offence, no other history of offending.
Well, you say that these are the judge's reasons for saying that the presumption has rebutted, but when you actually read what she says, she's weighing up the evidence in the round, yes, and that he has rebutted the presumption taking account. So I'm not sure she's suggesting that all of these 4 factors that she highlights all point in the same direction.
I accept that, yes. Lord, paragraph 39 is where the judge says that for all these reasons, I find that presumption has been rebutted.
Yeah, but in fairness, I agree, my lord. In fairness to the judge, she was likely, if giving serious consideration to this issue, to have to note, and if she'd simply said, I note that he has no other criminal convictions, that presumably is a relevant matter. In other words, this person is not a career criminal. So that could not be objected to, could it?
No, the way I...
It's got to come in some way.
I accept
in the general balancing exercise.
I accept that. But in my submission, when you will read 38 A and B, A is that there's only one conviction, and B is that since release he hasn't committed a further offence. The judge, in my submission, is taking those matters into account in KD's favour in making the assessment. The submission that I make is that those matters at best are neutral matters.
Yes, well, that's putting it in a different way.
Yes.
All right.
So KD is expected, is obliged not to commit crimes. The fact that he hasn't committed another murder or hasn't reoffended is not a point in his favour. It is, in my submission, a neutral point, not a point to be taken in his favour. He is assessed as presenting a low risk of reoffending. The judge, again, in my submission, fails to consider whether the low risk entailed a real risk as required by EN. He was initially assessed, this is point D, initially assessed as medium high risk of serious harm to partners, but that was downgraded by the probation service as a medium risk. Again, no doubt the risk is real. The judge, in my submission, has not applied her mind to that particular question. So for these reasons, I submit that the judge erred in law, failed to apply EN in substance, made a finding that is perverse or inadequately reasoned, and arrived at a conclusion that was not open to her.
Well, I appreciate you have to deal with the way in which the judgment was put, but as I understand at least part of your case, it is that with an offence of this gravity, tribunals have to understand that the burden on somebody to displace the statutory presumption is an extremely heavy burden.
Yes.
It's bound to be. And one is not starting in the same position as if one had somebody who had crept over the 2-year or the 1-year sentence.
Yes. So, particularly serious, I took that regards to you, I took you to paragraph 45 of EN, where they made, Dr. Seliburton makes the point where the offence is particularly serious, then the appellant is likely to constitute danger to the community as long as there is a real risk. And you have my submission that
yes.
A sentence of life imprisonment is at the top end of all possible sentences. Greater the sentence, the more difficult would it be, in my submission, for an appellant to rebut the presumption. But the reasons that the judge gave in my submission are inadequate and do not justify my conclusion. So this in effect, my lords, is ground 2.
Thank you.
So I'll deal then next with grounds 3 and 4 together. And I will take you to 3 authorities on the subject. The first is the judgment of this court in BK, Afghanistan. That judgment, Lords, is behind tab 1 of the authorities bundle. And this is the authority where this court endorsed Diva-Celine guidelines. Now, if you go to page 7 of the authorities bundle, you will see that Lady Justice Rose, as she then was, summarized the case of Diva-Celine. Right at the end of page 7, you will see that there was an asylum appeal that was dismissed by the adjudicator, and that was the context in which the second proceedings were commenced. So the first decision is not binding on the second decision maker. There is no dispute about it. But if you look at the last two sentences of that particular paragraph, it is not the second adjudicator's role to consider arguments intended to undermine the first adjudicator's determination. But the second adjudicator must be careful to recognize that the issue before him is not the issue that was before the first adjudicator. So identification of issue, in my submission, is absolutely essential. If the first adjudicator had decided that a person is not a refugee at that particular point in time, and the second adjudicator is deciding whether a person is a refugee, when the second adjudicator is making the decision, the issues are different, because the decision is being made in a separate point in time. But where the issue, for instance, is whether a person was a member of a particular political party in past, if that is the issue that the first judge has looked at, and that is the issue that the second judge is looking, then the issue remains the same. And a different approach, in my submission, applies in those circumstances. But the point is that a judge is required to be careful to identify the issue that the judge is deciding. The guidelines are at paragraph 32. There are 7 guidelines. Guideline 4 is of particular relevance. Facts personal to the appellant that were not brought to the attention of first judge should be treated with the greatest circumspection. And ground 5, evidence of other facts should be treated with caution. So where, for example, in the first asylum proceedings, a person says that he is at risk of persecution, but fails to mention that there is an arrest warrant against him, and that arrest warrant surfaced in the next appeal proceedings, the judge must proceed with caution and consider that with care.
So do you put the arrest warrant under 5 rather than 4?
Yes. There is lack of clarity when I'll show you the decision as to when the arrest warrant.
Isn't that a fact personal to the appellant?
Yes, that's what it is. Well, I was assuming it was under 4.
Yes.
Yeah.
So
I think the other facts are things, you know, it's changed because there was an earthquake, or it's
yes,
something political. There's been a change of government, or something of that sort. May very well be other facts.
yes,
All right. Well,
yes, and then guideline 7.
What about 6?
Yes, of course. No,
Because
yeah.
one of the things that the first judge found
Yes.
Was that that KD and his wife were lacking in credibility, and therefore the entire account of his political involvement up until the time when he left Turkey didn't even satisfy him on the lower standard that applies in cases of this, that then applied in cases of this sort.
Yes. Yes. My submission is that when the first judge made a finding that this was a wholly fraudulent claim.
Yeah.
KD was never a supporter of this organization, was never a member. Then that, in my submission, is the conclusive resolution of that particular issue.
What it says is the second adjudicator should regard the issues as settled by the first adjudicator's determination and make findings in line with that determination rather than allowing the matter to be relitigated.
Yes, so surely the second adjudicator was perfectly entitled to form a view as to whether KD was a refugee at the point when the second adjudicator was making the assessment. That is a different issue. But there is a sub-issue here, which is whether KD was a supporter of this organization or a member or came from a political family. That issue was determined by the first judge, in my submission, conclusively determined by that judge. And the second judge should not have allowed that particular issue to be litigated. But that does not mean that the second judge is not, in principle, entitled to allow the appeal on some other basis. But that means that that particular issue is resolved, it's settled.
Well, subject to Guideline 7,
Yes.
if there's some very good
Very good
reason
Yes.
for the appellant's failure to produce relevant evidence before the first adjudicator.
Yes. So this court has said that this reflects the Ladin-Marshall principle in civil jurisdiction. So if very good reason equals to Ladin-Marshall, if there is...
Well, it goes a bit further because, I mean, Ladin-Marshall, of course, you have to show that the evidence couldn't be obtained with reasonable diligence the first time around, whereas very good reason could extend to other circumstances, at least in theory.
Yes, now this court has said that this mirrors Ladin-Marshall principle, but of course that principle is also subject to an exception, which is that the court may allow an issue to be litigated if it is in the interest of justice.
This is paragraph 38, is it?
Yeah.
That you're referring to in the Ocampo decision.
No, there is actually a more recent authority case called Patel, which is in the bundle.
Yes, but in a way, it's the earlier ones that are more helpful because we see from 34 that this court approved, or I think approved, the Diva-Seelan approach very soon in 2004, and the point was being made about Ladin-Marshall in 2006, paragraph 38. So it wasn't just BK.
Yes.
That this court turned its mind to this. It's been a long-standing approach.
Absolutely. I mean, there are. I once counted over 20 authorities of this court where Diva-Seelan principles were considered. But these are the guidelines that have survived all those judgments over 25 years. But the fundamental point is that
one of the dangers with that is that judges think they know what they mean by saying Diva-Seelan.
Yes.
But actually could benefit from going back to looking at the 8 principles before they deploy Diva-Seelan.
Yes. So the next authority that I will take you to.
I'm sorry to ask you one more question, but just I'm sure that Lady Justice Rose summarised Diva-Seelan perfectly at paragraph 32. Have you any difficulty with that summary?
No. This is taken directly from Diva-Seelan. So that is
taken directly from what was set out by the Upper
The
Tribunal.
guidelines are Diva-Seelan guidelines taken from that decision.
Yes. All right.
Now, the next authority is the recent judgment of this court in Tomlinson, where this court revisited BK Afghanistan and these guidelines. It's tab 12 of the authorities bundle. A different case on facts, but the court sought to reconcile principle of res judicata with these guidelines and how things fit in. Now, if you go to paragraph 52 of the judgment, this is page 210. You'll see a reference to BK Afghanistan, the paragraph that I took you to is quoted at paragraph 51. And you'll see that the point that I just made was acknowledged, that the issue between the two adjudicators are not usually the same when it comes to asylum and immigration cases, because the assessment is made at a different point in time. But what is relevant, if you look at the next paragraph, paragraph 53, it's right at the end of that page, going on to the next page. The guidance applies to findings of fact in the circumstances where the issues are not the same. Well, this is all guidelines apart from guideline 6, which of course concerns issues that are the same. So a judge must identify what the issues are and form a view as to whether the issues are the same or different as were decided in the first set of proceedings. If the issue is the same, then the second judge must treat the issue as already decided and make the assessment on that basis. Now, in this case, of course, one of the points that KD made was that he would be at risk of persecution because he had murdered his wife and the family would seek revenge. That, of course, is an entirely new matter, a new issue. The second judge, Judge Scott, was perfectly entitled to make whatever findings of fact he wanted to make about that particular issue. But in my submission, the other point that KD made, that he was a member or supporter of this particular organization, is a point that was conclusively decided by the first judge, and Judge Scott was obliged to make the assessment on the basis that the issue had already been determined.
I'm not looking for difficulty, but is there some difficulty in paragraph 53 that you've just referred us to? So what's the context? Can you just help us as to in which they're thinking about res judicata? Why are they in that territory? In that case,
there is the principle of res judicata does not apply, this court has said, in asylum cases. The reason for that, my lord, is that when a judge is making a decision on an asylum appeal, the judge is making a decision on whether a person is a refugee at that particular point in time. The first judge in an asylum appeal would have decided that a person is not a refugee at that particular point in time. For that reason, this court had taken the view that res judicata principle would not apply. But what this court is saying here is that there could be a sub-issue which does not depend or does not change with the passage of time. And an issue of that sort is an issue where these principles do not apply. And if there is a finding by the first judge, then that is a finding that stands.
Yeah, it might be helpful to look at paragraph 66, where Lady Justice Falk summarises her conclusion. In subparagraph C, she says issue estoppel requires identity of issue, commonly not the case in immigration because it's a different, being assessed at a different time in light of prevailing circumstances. But then in D, she says exceptionally identical issues may arise, and then issue estoppel can apply. But then perhaps more importantly for our purposes, in E, she says even if the issues are not identical, to the extent that facts are relied on not materially different, they should be regarded as settled under D facile for reasons of fairness that also apply underpin res judicata. So it's a similar approach, although it's not strictly res judicata.
Very grateful. So the context of that case, just to answer the question, my Lord, was that it was a deportation appeal that succeeded. The appellant in that case, then following the success of that deportation appeal on Article 8 grounds, made an application for entry clearance to the UK. And the Secretary of State refused that application on the basis that the requirements of the rules are not met and the refusal would be compatible with convention rights. He then issued judicial review proceedings saying that the issue had already been decided by the first judge. And it wasn't open to the Secretary of State to depart from those findings, and that was the context in which there was a discussion.
Right, and just so I'm clear, are you putting your appeal on the basis that because there was a finding in 2004 about the extent of membership
Yes.
of a political organisation, that was something that that raised an estoppel? Or are you simply saying that a proper application of the Diva-Seelan guidelines effectively leads to the same outcome without treating it as a civil law estoppel principle?
It leads to the same outcome. I'm not putting my appeal on the basis of estoppel. I'm putting my appeal based on Diva-Seelan.
There sometimes is no reason why one would want to improve on the original source material.
Yes.
And the way in which Diva-Seelan deals with this is to deal with the which doesn't appear from the authorities you've taken us to so far, is to deal with the cases in different categories. And the category I think that we're engaged with appears at page 23 of the authorities bundle, where a specific disaggregation is taking place of the kinds of Diva-Seelan circumstances that can arise. And we looked at criteria 6 earlier as abbreviated by Lady Justice Rose, but paragraph 41 of Diva-Seelan sets out very clearly that before the second adjudicator relies, before the second adjudicator, the appellant relies on facts that are not materially different from those put to the first adjudicator, proposes to support the claim by what is assessed the same evidence, second adjudicator should regard the issues as settled by the first determination.
Yes.
And that's the question, the phrase, the starting point, treat it as the starting point, is actually right at the start of these principles being set out as a general overview, but there's a little more detail as to the approach when one sees the criteria set out fully in Diva-Seelan.
Yes.
But it also, as my daughter has pointed out, the gateway is to dealing with it this way is that the appellant relies on facts that are not materially different. So one could see that an appellant a second time round could simply introduce facts.
Yes.
That then the argument is, are they materially different or not?
Yes. But I do want to make it absolutely clear that I'm not suggesting that these are stringent, inflexible guidelines that must be followed in every single case. There is always an exception.
Yes, if the principles of estoppel are not they're not flexible and so forth. They're extremely bright and clear.
Yes.
Either it applies or it doesn't.
Yes. But Diva-Seelan guidelines are flexible enough to enable the second adjudicator to consider why the relevant facts were not identified at the relevant time.
And also, but also as a consequence, explain why.
Yes, yes. If, for example, the appellant was too unwell to give evidence, then it could be said that it is in the interest of justice to depart from the principles, or there is very good reason why the relevant facts were not.
Well, Tomlinson is, the underlying principle is fairness. Not the first time that's been said, but fairness to everybody.
Fairness to everybody, precisely. Now, there are other authorities as well on these guidelines. I do not propose to take you to them. My learned friend may take you to one or two other authorities, and if he does, then I'll deal with them in reply. The only other authority that I'll take you to is Tanveer Ahmed. Well-known authority, again, an authority that has survived scrutiny of this court over 25 years. That is behind tab 11 of the bundle. And this is the authority that sets out the proper approach to the documentary evidence in asylum cases. If you go to paragraph 31, you will see a point that in my submission is relevant and provides the context in which you'll actually consider these guidelines. Now, it's well settled, my lords, that when a judge makes a decision in asylum immigration cases, then the judge must not assess the facts as they would happen in this country, but make the assessment by reference to the objective circumstances in the country of origin. The tribunal in Tanveer Ahmed said that also applies to documentary evidence. The example is that if a person says that he was tortured by police in Turkey or in some other country, then the judge is required to assess plausibility of that account by reference to what happens in Turkey as opposed to what happens in the UK. The same point applies to documentary evidence. One knows from experience and objective evidence that in some countries it's quite easy to obtain forged documents. Some documents would be forged, not genuine, but then some documents would be genuine but worthless. For example, birth certificates, warrants, court's judgments originating from an official source but unreliable. So I do ask you, Lords, to read paragraph 31 in full. And that is the context in which the guidance was given, that in asylum cases, unlike civil proceedings, the focus must not be on whether a document is genuine or forged. The focus must be whether a document is reliable. It is not for the Home Office to make inquiries about whether a document is forged or authentic. This is paragraph 36, and the guidelines are at paragraph 38. The burden of proof, unlike civil cases, in asylum cases, is on an applicant to show that a document on which they seek to rely can be relied upon. And the decision maker should consider whether a document is reliable, having looked at all the evidence in the round.
The emphasis on reliable.
Yes. And the burden being on...
But also the other thing is, I mean, a document, let's suppose a document is a forgery.
Yes.
I mean, as we well know, the fact that a forgery is a written lie, the fact that somebody in proceedings has lied, doesn't mean that they're not in grave danger. I mean, somebody may very well produce a forged document for their own protection in circumstances when they're in very real danger. So
yes.
It's using the genuineness of a document as a surrogate for the overall assessment is clearly an inappropriate course.
Yes, yes. But the point is that the decision maker decides whether a document is reliable after considering all the evidence in the round. Now, with these three authorities in mind, may I then show you first the decision made in the original asylum appeal, and then how Judge Scott dealt with the issue. If you go to page 130 of the bundle, you'll see the original appeal decision. And if you look at paragraph 4 of that judgment, you'll see the claim that was put to that judge. 4 points were made by KD. This is paragraph 4. The first point is that he came from a political family. This is line 7. He came from a political family, and his family members, in particular brother and cousin, were involved in DHKPC politics. That was the first point. The second point that he made in the asylum claim was that he worked for DHKPC. He distributed literature and was involved in, he distributed literature for DHKPC and was involved in political activities. That was the second claim.
Are you drawing this from particular lines in this paragraph, or are you just summarizing?
No, just drawing this from I mean, this is of course a lengthy paragraph. If you look at perhaps just middle of that paragraph, he was between 1994 and 2000. He remained in the village and continued his political activities.
Yes, I was just alerted by you suggesting he worked for.
So my apologies. That was my summary. So if you look at three lines above, he distributed literature.
Yes.
So when I meant work, I meant that kind of work.
Yes. Okay.
The third, so that was the second one. The third point was that he was arrested and tortured on 4 different occasions. And those dates are set out within that paragraph. And the fourth claim was that he fled the country because of the fear of persecution. So that was the claim that he made to the Secretary of State. Something remarkable happened during the course of the hearing. If you look at page 136, and if you look at the last sentence of paragraph 15, this is his evidence, his written evidence, that KD claimed that he became an important activist for DHKPC because of his regular activities in his area. That was his evidence. I've shown you his claim. The judge at paragraph 16 said that his claim was exaggerated, it was vague and lacking in credibility. And the judge gives reasons. And the claim wasn't credible. But what is truly remarkable is what appears at paragraphs 17 and 18. He departed from his written evidence. And he denied before this judge working for DHKPC at all. Now, if you look at paragraph 17, you'll see that he suggested during the evidence that he was not distributing leaflets for DHKPC, contrary to what he has said previously. The judge took things on his own hand. This is paragraph 18. And said, this is middle of that paragraph, that to ensure that KD was able to understand the implication of the contradiction, the judge read him the reasons for the refusal and paragraph 28 of his evidence. And then a question was put to him that whether he specifically denies any involvement with DHKPC. He first said he couldn't understand, but when the question was put again, he replied in the affirmative. So he told the judge, the first judge, he effectively denied categorically of being involved in DHKPC at all. The judge then says, end of that paragraph, that he was satisfied that KD understood the significance of this question and answered it. The judge concludes at paragraph 20 that this evidence is manufactured. There is no evidence of involvement at any level of DHKPC.
Right. HOP is a human rights organisation, as described in the various documents we have.
The judge then gives detailed reasons as to why the claim is just not credible. Paragraph 22, last sentence, the judge said that it wasn't credible that they fled the home area because of the fear of persecution. There are then sort of detailed reasons for these findings, and the ultimate conclusion is at paragraph 36. I find the appellant was found to be hesitant, confused, vague, and evasive. Looking at all the evidence in the round, the judge found that the appellant KD had submitted a wholly fraudulent asylum application with no truthful foundation. Last paragraph. Judge rejected completely his account that he came from a political family, he was arrested, tortured, that he was a member or supporter of this organization. Wholly fraudulent asylum application. Paragraph 37, middle of that paragraph, there is no risk on return. And the judge then considered the documentary evidence, applied Tanveer Ahmed, and rejected the documentary evidence that was provided. There is a clear finding at the end of paragraph 37.
Can we just be clear about what documents?
Yes.
The judge will have been referring to in 37.
Yes. So these are discussed within that paragraph. So if you look at the last 8 lines, you'll see that the judge found the witnesses to be wholly unreliable. There is a finding that they do not come from a politically significant background.
Well, it says at the bottom of page 19, I've been asked to accept various copy letters contained in the appellant's bundles with regard to, and then some individuals, including KD's brother.
Yes.
Are those the documents? And then his rep, Ms. Bond, says she's been instructed that they have refugee status. Are those the documents and the factors that he's rejecting in the context of Tanveer Ahmed? He says there's nothing, top of the page 20, there's nothing before me to indicate any of these individuals have been accepted as refugees. None of them attended court. Yes. Nor were there on the evidence before me, I've found that Mr. and Mrs. KD to be wholly unreliable.
Yes.
I don't accept either of them come from a politically significant background, nor that the relationship we have, if any, to these individuals whose documents are photocopied is significant in placing them at risk.
Yes, so we're not really talking about documents, but we're talking in a sense about a letter standing as an account from family members. The brother is somebody who didn't give evidence.
Yes.
Although he was in the United Kingdom.
Yes.
At this point, but then came along and gave evidence. Second time round.
But the point is that this is, in my submission, the proper approach to documentary evidence. Look at the documentary evidence that is produced.
I understand, but what we were talking about before was really to do with certificates of this and official documents of that kind. It would be the classic sort of documents we're talking about. I mean, here, in a sense, what
Yes.
the judge is dealing with
Different.
witness evidence, which he wasn't prepared to place any weight on at all, by means of letters from family members. Not to do with really with genuineness; it's just to do with weight, isn't it?
Yes, on
No weight given.
reliability. I'm not entirely sure whether there were other documents photocopied in the bundles, because we don't have those bundles. But the point here is that there is a sort of wholesale rejection of his credibility. And the documents that he previously had used were found not to be reliable. So this is what the first judge held. If you then look at Judge Scott's decision, page 76 of the bundle. If you first look at paragraph 12 of the judge's judgment, judge's decision, you'll see a summary of the account that was put to the second judge, Judge Scott. There were two distinct issues. The first was a blood feud. That is entirely a new issue. Judge Scott was perfectly entitled to make fresh findings. The second issue was that he was a supporter or member of DK HPC, precisely the same issue that the first judge considered. Judge Scott makes findings of fact as to blood feud at paragraphs 41 to 59. And I accept that Judge Scott was entitled to make those findings of fact. But those findings were surely not enough for the judge to allow the appeal, even if there is a blood feud, even if the wife's family seeks revenge. KD is not a refugee unless KD demonstrates that Turkish authorities would not provide sufficient protection, or that it wasn't possible for him to internally relocate to a different part of Turkey, to Istanbul or to a major city. And this is where Judge Scott, in my submission, erred. If you look at the heading imputed political opinion just above paragraph 60, the judge there considers that aspect of the claim. Paragraph 60 onwards.
Thank you.
The judge there acknowledged that the first judge had made adverse credibility findings, and that those findings were Judge Scott's starting point. The judge then took the view that there is now new evidence, and that entitles the judge to depart from the first judge's findings of fact.
I don't want to be pedantic, but and I may not even be right, but when the judge said I treat the first judge's findings as starting point, is it your case that unless she's going to provide very good reasons, then those are also the finishing point in relation to an identical issue?
Yes.
I mean, in a sense, to simply treat them as a starting point for a topic which, if you're right, is the same topic, would be an inadequate reflection of the exercise that's being carried out.
Absolutely, and this is the point that my Lord Lawrence Reserve made, that it's not uncommon in this jurisdiction to see decisions where a judge would simply say that I treat the first decision as a starting point, just picking the first sentence of the guidelines. but then simply ignoring the subsequent guidelines. And this is what, in my
And where the case fits
litigation.
in terms of that careful categorisation that was undertaken by the Upper Tribunal in the Asylum, which sadly doesn't appear to have been
Yes.
altogether reflected in the way in which this court has dealt with that authority.
Yes. So the fundamental error by the judge is that there is no recognition that this particular issue is the same issue that was decided by the first judge. It is absolutely essential for judges to recognize the nature of the issue. As this court said in BK, emphasized again in Tomlinson, no recognition that the issue, this particular issue, is the same issue. If you then look at the judge's reasoning, last sentence of paragraph 62, first sentence of paragraph 63, even if I'm wrong in the first point that I've made, these witnesses said that KD was involved in politics with DHKPC, and the appellant was a supporter of DHKPC. I have shown you the first decision where his account changed materially before the first judge. He categorically denied before the first judge being involved with DHKPC at all. To ensure that KD understood what was happening, the judge took time to read the relevant parts of the decision and his statement to him. A question was then asked, and he said he denied being involved with DHKPC. So no recognition there in my submission of the findings that the first judge made and why those findings were made. Paragraph 64, this is where the judge considers an arrest warrant that was issued by IST State Security Corps. And you'll see that the warrant is dated 2nd of August 2001, well before the first adjudicator's decision. A further document from the Office of Chief Public Prosecutor, dated 15th of August 2001, and also an indictment dated 2021. Under cross-examination, KD was unable to recall when he received those documents. If, for example, he had said that, well, he received those documents only in 2021 or 2022, and there were some good reasons as to why that would be the case. In principle, that would have enabled a judge to scrutinize that claim and decide whether fairness required departure from the first finding. But he did not even say that those documents were received only after the first judge's decision. Paragraph 66, when it was...
Well, paragraph 65 seemed
Yeah.
to me to be of some significance as well, which was that the appellant's own case was he didn't know what he would face when he returned.
Yes.
And that was his case. I appreciate it's not the whole of the evidence.
Yes. I've shown you the first judge's decision. It's rather difficult in my submission to understand what the claim is. So at one point he was saying that, well, he's at risk because he's member supporter of this organization. He then says that he's not, but he then maintains the claim. And he then says that, well, he is not sure what the position is.
Okay.
But in fairness to the judge actually allowed the appeal for reasons based on the evidence from other witnesses. If you look at 66, so of course, Lord, you're absolutely right that 65 is what the appellant KD said. But when a question was asked to a witness, the brother, as to why the appellant would be at risk, he stated that it was on account of him being a member of DHKPC. If he is truly a member of DHKPC, one wonders why he did not say so before the first judge, and why he denied any involvement with the organization. And that is the same issue that was dealt with previously. The second witness, paragraph 67, was asked the same question, and he said that the appellant would have problems due to his political background. So membership of DHKPC, one point. Political background, he comes from a political family, that's the second point. Well, both these points were rejected by the first judge. These were live issues in the earlier appeal proceedings. The judge concludes that, Judge Scott says that she would depart from the first judge's findings, this is paragraph 68, because there is new evidence which supports KD's case that he is a supporter of DHKPC. Again, no recognition of the fact that it's the same issue that was dealt with previously. And then within that paragraph, you'll see that the new evidence on which the judge relied also included the arrest warrant and other documents. So no assessment in my submission of whether those documents are reliable.
Well, there's the reference to the murder of Dilek, which is perhaps the most striking
Yes.
event that was being put forward. So how was the judge to deal with that?
Yes, I mean, I take no issue with that particular point. That the submission that I make is that when the judge was placing weight on the arrest warrant, the judge was obliged to consider whether that was a reliable document. It was for KD to establish that those documents were reliable.
But surely the question that one's really curious about is whether they matter 25 years later or
Yes.
20 years later.
Of course.
I mean, nobody's applied to extradite him,
No.
so far as one's aware.
Yes.
So there are all sorts of questions that might be asked about this.
Yes. Of course, those are the sort of secondary questions. The reason why those points are not at the forefront of this appeal is because of a country guidance decision from 2003 and 2004. Perhaps it's too old, but the law is that.
Is this mentioned in 70?
Yes, 70 and 71. Yes, but I rather than focusing a lot on that particular point, I focus on the prior point, that where someone produces an arrest warrant in the circumstances where one judge has said that this person submitted a wholly fraudulent asylum application, Judge Scott was obliged to consider whether that document is reliable in the light of the earlier findings.
As I understand, your general point about this is that the sort of evidence that the judge was now hearing, not suggesting agreement or otherwise with what your case is, but really fell very far short of entitling her to depart so comprehensively from the judge who was making these decisions at the time.
That is indeed one of the points that I do make. But you have my prior point that there is actually a misdirection in law. If a judge appreciates what the task is and gives adequate reasons for departing from the first judge's decision and finding that documents are reliable, in principle that is fine.
So what we're seeing here is not a faithful application of diva sealing.
Yes, that in my submission, yes, and indeed Attorney Arnold. It's not enough to say that, well, there is an arrest warrant and that is new evidence, and the appellant and KD is a refugee because of it, without assessing the reliability of that evidence. no consideration of reliability of the documentary evidence, no consideration whatsoever of why these documents were not produced earlier in the earlier appeal proceedings. No assessment of whether there is very good reason for not producing these documents earlier. So this, with respect, is simply unsustainable. So paragraphs 70 and 71, the judge applies the country guidance. There can be a question as to whether those country guidance decisions are valid, but it's not a ground of appeal. If you look at 71, the judge departs from every single material finding that was made by the first judge. So 71A, I find that KD was involved with DHKPC. The first judge's findings were not sort of merely a starting point. They were findings of fact that this judge was obliged to adopt, absent very good reasons as to why the relevant documents were not produced earlier. I find that arrest warrant was issued and the appellant was detained and arrested. Again, the same issue that was decided by the first judge. Absent very good reason why this arrest warrant wasn't produced earlier, there was no basis for this judge to depart from those findings. And the same then applies to other documents. And the judge therefore took the view that there is a risk of persecution because of KD's political opinion and support of DHKPC. And that, my lords, was the real reason why the appeal succeeded. Because if you look at the question of internal relocation and protection, this paragraph 73, the judge said that there is no adequacy of protection and internal relocation is not an option because there is a risk from the state authorities. The judge would have not made that decision if the judge had not made findings that the judge made at paragraph 60 to 72. In principle, a judge in a case of this sort is entitled to allow the appeal on the basis that there is a risk from family. That risk is based on an entirely new matter that wasn't adjudicated previously. One judge may find that there is no adequate protection in Turkey for all sort of reasons, and it's not possible for a person to relocate to a different city. But we don't have those findings here. The judge said that well, that doesn't matter at all because there is a risk from state authorities. The judge, in doing so, departed entirely from the first judge's decision, and therefore, in my submission, erred in law.
It's, from some points of view, paradoxical that somebody's ability to remain in this country should be improved as a result of them killing their wife.
Of course.
Is that just an idle thought, or does it actually have any legal heft?
Well, it is paradoxical and quite a point to make.
Well, it is quite a point to make. Sorry, I was just going to say. I mean, what's the result? That it has no result, or that the tribunals faced with an appeal of this sort
doesn't really factor into any of your grounds of appeal, because grounds 3 and 4 are all about political opinion, not about the blood feud.
Yeah. I mean, yes. I mean, it is. I mean, one can see irony in the point that the Secretary of State wants to deport this person because he has murdered his wife, and this person says that you cannot deport me because I have murdered my wife. But I have to accept that in principle, it is possible for one judge to allow an appeal on that basis.
But as you rightly pointed out earlier, that's not in fact what happened.
Yeah.
Because although the blood feud was accepted, the issues of sufficiency of protection and internal relocation weren't determined on that basis. So, at least in theory, and maybe in reality, that would not have been a bar to deportation, because even though there was a blood feud as a result of the murder, nevertheless, KD, if returned to Turkey, would be either sufficiently protected and or could relocate internally.
Absolutely. So, if my lords are persuaded with any of the submissions that I've made, of course, the case will go back to the fact finder, to the first-tier tribunal. KD will face, in my submission, an uphill struggle, near impossible task of persuading a judge that Turkish state would be unable or unwilling to provide protection, or that it wouldn't be possible for KD to relocate from his village to a different part of Turkey where no one knows him, and the wife's family would know that he has returned and would seek to revenge. But if he was from a different country where there is greater or compelling objective evidence of deficiencies in state structure, where there is evidence that state authorities are unable and unwilling to provide protection to its citizens, the outcome could be different.
I might have thought that one way in which the paradox might be addressed is that one does have to look with particular care at the decision-making process. And so where one's faced with an application which has that complexion, then it doesn't mean, as you say, that it inevitably fails, but that it's bound to be scrutinised extremely closely.
Yes.
Right. What I'm also wanting your help about is that we get to the end of page 18 of the judgment, and then things end quite fast. That the judge has dealt with, as a concomitant of her finding about the political activity, the protection, the state protection issue in a paragraph at 73. But no more than that. But then she goes on, in effect, to reach no conclusions about the blood feud question. It would clearly have been helpful, would it not, had the judge set out what her view about that was, lest her view in relation to state protection was ill-founded. I mean, because I'm not really sure why she was hearing evidence about a blood feud, in a sense. I mean, where did it all go after having heard it? If you then, if having heard it, then you don't say anything about it.
Right, absolutely. So if you look at paragraph, you've seen paragraph 73. If you look at the last sentence of paragraph 75, I'm sure you've picked that already, where the judge says that, categorically says that, well, I've not gone on to consider sufficiency of protection, risk of relocation in respect of blood feud.
Well, she'd heard and read an awful lot of evidence about stuff that had been going on, and there's zero product, pretty much, in relation to that, which I think you're accepting that that would mean on its own that the matter would have to go back and couldn't be dealt with in this court.
Yes, unless I show you the underlying objective evidence, which is set out in the Secretary of State's decision, but it wouldn't be appropriate use of this court's time.
We haven't seen the primary evidence.
Yeah.
This hearing is not set up for submissions about it, and so it would be completely inappropriate for us to do that. But
But on the basis they're not challenged, what is your submission about whether the findings in relation to the existence of the blood feud should be preserved if it were to be sent back?
The judge found that there is a blood feud, and the fact is that that finding was not challenged on appeal to the Upper Tribunal.
Yeah.
And it is impossible for me to mount a challenge to that finding in this appeal.
Yes.
So I don't have a problem with the finding that there is blood feud, because despite that finding, KD faces an next to impossible task of persuading a fact finder properly directed that a blood feud places KD at risk of persecution in a state like Turkey.
But it's not so much persecution, I mean, because blood feud doesn't give rise to a convention, a refugee convention right. It's to do with human rights and protection in that way. Isn't that the way we need to approach it?
I mean, a victim of blood feud, the courts have said, can in principle fall within particular social group territory, but certainly not in my submission in relation to a state like Turkey.
No, but I think the point I'm trying to make is that, just to answer my Lord Justice Peter Jackson's point, is that the judge may have dealt with this not because she was trying to beat the air, but because having received all of that factual material, it was appropriate for her to make factual conclusions about them, because she wouldn't know which way the procedures were going to go after that.
Yes.
And
And this is all. I'm sure my lords would know that this is all subject to my ground too, which is about which is about exclusion.
Yeah.
If KD is excluded, then
none of this arises.
Yes.
Then grounds 3 and 4 would not really matter, because he would then be unable to succeed on refugee convention grounds anyway.
Yes, but he does have other grounds.
Yes, he would in principle be able to pursue an Article 3 appeal.
Yes, that's what I was referring to.
Yes.
But I mean, you say, I appreciate that there's no. Well, we're talking now about disposal against an assumption which is very far from being made, that you to some extent succeed on your appeal. That the hearing in front of the first-tier judge took place in November 2022. So her findings were effective 3 years ago.
Yes.
But yet you say that her finding in relation to blood feud can endure.
Yes. So, of course, that finding was not challenged in the Upper Tribunal. It's not challenged in this court.
Yes.
But if the court is persuaded that there is an error of law in Judge Scott's decision, then the court decides whether to set aside that decision in the exercise of your discretion under the statute. In my respectful submission, you're perfectly entitled to set aside the decision in its entirety, despite the fact that one particular finding wasn't challenged. You get the power to set aside the decision from your finding that there is an error of law in the judge's decision.
So it would depend upon our evaluation of the degree of concern we felt about the decision that had led us to allow it, and to the extent to which it's appropriate to separate out issues.
Now there is some guidance as to the circumstances in which the Upper Tribunal or this court should preserve findings of fact. On remittal, the experience tells us that increases the difficulty of a fact finder as to how to adopt.
Some are preserved, some are not preserved, and so forth, within a single issue.
Within a single issue, precisely. So the courts have said that if there is a remittal, then the court should consider very carefully as to whether it is appropriate to preserve any findings of fact at all.
Because I'm thinking about this in terms of a hypothetical rehearing in some tribunal, which was about how dangerous it would be for the appellant if he was respondent if he was in Turkey, limited only to issues of internal relocation, for example, or limited only to how much help will the police give me if I feel threatened, with the judge having to proceed on the basis of, in this world, an overturned decision as to the existence and nature of the blood feud, because the judge would be hearing witness evidence about these matters, but only about some of them.
Yes.
So I think I've myself understood what the parameters of this debate are.
Perhaps just make one particular point again, not seeking to challenge those findings. There is a previous finding that this person submitted a wholly fraudulent asylum claim. He previously submitted a fraudulent asylum claim, and that surely is also relevant to his overall credibility and what this person is saying. And therefore, I would ask you, Lords, to consider not preserving any findings of fact if you are persuaded that there is any merit in the grounds that I have pursued. So that a new judge can look at the evidence afresh and make whatever findings of fact they wish to make.
The other question is in relation to which tribunal should this be remitted, and as Lord Justice Dove knows, there's some learning about this, and we have a situation, as I understand it, where the first tier is extremely pressed at the moment. That, as I understand it, this individual has been in this country for a quarter of a century without any right to be here.
Yes.
And there's no end in sight to this matter if it were remitted to the first-tier tribunal. There may be circumstances in which it would be basic fairness to, as it were, allow for a trial because a trial simply hadn't happened. But is it open to us to remit it to the Upper Tribunal?
Absolutely. So the Upper Tribunal is perfectly entitled, capable of making findings of fact. So an Upper Tribunal judge can...
It doesn't deprive anybody of appeal rights, because it would then be a first appeal.
It would still be a second appeal, but the threshold for grant of permission would be slightly different.
Yes, absolutely. In other words, it would be accepted that it was the first attempt by either you or the respondent.
Yes, no unfairness to KDE, and in my submission, it is perfectly legitimate to have regard to the case law at the first-tier tribunal in deciding whether a remittal to the first tier is appropriate or a remittal to the upper tribunal is appropriate.
Right, but is that something you leave to the court, or do you make a particular submission about it?
In light of, Lord, the observation that you made, I feel that the right course is to remit it to the upper tribunal. But of course,
I think the question would be, and we're in this, we're a long way away from being in this world, because we need obviously to consider all of the submissions. But the trouble is, once we've left this room, we won't have the benefit of both of you to assist. So we need to cover all of the ground. But the question would be, wouldn't it, had Judge Perkins found that there was an error of law, what would he have done? Would he have sent it back to the first tier, or would he have retained it in the upper tribunal for remaking?
He would have retained it for sure at the upper tribunal. Mallory, you're of course familiar with the guidance, with the senior president's practice direction. So where the upper tribunal set aside the first-tier tribunal's decision, the expectation is that the upper tribunal will remake the decision rather than remitting the appeal to the first-tier tribunal. There are two exceptions. The first exception is where there was some sort of unfairness to a party, and the party was not able to put forward their full case, that exception does not apply. Second exception is that where the nature of the case is such that a remittal is appropriate. This isn't that sort of case. If Judge Perkins had found an error of law, in all likelihood he would have retained the appeal and remade the decision at the Upper Tribunal. So if the submission that I make is that the court should set aside Judge Scott's decision, set aside Judge Perkins' decision, remit the appeal to the Upper Tribunal to be heard afresh. The appeal from the Secretary of State's decision be remitted to the Upper Tribunal to be heard afresh.
There's then the separate question in relation to the issue of danger to the community. That, speaking for myself, strikes me as something that we can choose to either determine ourselves or to remit because it doesn't call for any evidence.
That's right, yes.
I mean, obviously we'll be helped by the couple of things that you're going to be submitting in relation to process.
Yes.
But it may not, depending upon the view we take, having heard all the submissions, be necessary to for that to be reconsidered. In other words, we can either say we're perfectly happy with Judge Scott's view on that, and that will remain part of the furniture, or that we're not happy with it, and it will be reversed.
Yes. So on the evidence that is before the court, that is dealt with within the decisions, there is surely a real risk here. That's not
I wasn't inviting you to reignite your point on that. I was simply saying that it doesn't seem, speaking for myself, to be in the same category as matters that will need proper evaluation.
Yes.
That there's probably a right or a wrong answer to that.
There is, yes. Unless my learned friend tells you that there is, things have changed significantly, and
yes,
you know there is now some new evidence. So no, these are my submissions on grounds 2, 3, and 4.
Yes.
Be very brief on the first ground. If you're not with me on these grounds, in all likelihood you'll dismiss the appeal. And if you are with me, then you need not to look at the first ground. The reason why the Secretary of State pursued ground 1 is because of an observation that Judge Perkins made within his decision, namely that the Secretary of State wasn't able to say much at the appeal hearing. And I can take you to that particular observation. If you look at Judge Perkins' decision, starts at page 49. There's no dispute that there's a gap of 12 months before the date of the hearing and the date of the decision. If you look at paragraph 28, you'll see that Judge Perkins said that Ms. Arnold, who appeared for the Secretary of State, could not say very much about the decision, that the claimant is not a danger to the community. Now this decision, as the court may or may not know, has received some media attention. And that observation, with the greatest of respect, wasn't a fair or justified observation. Ms. Arnold made detailed and comprehensive submissions on that issue to Judge Perkins. If you wish to see those submissions, they are at pages 55 to 60 of the bundle. She addressed Judge Perkins at length. In all likelihood, and I say this with the greatest of respect and diffidence, that the gap between the date of the hearing and the date of the decision was the cause why Judge Perkins wasn't able to recall precisely the submissions that were made.
Just moving quickly to this is a post-hearing report, which appears to be an amalgam of a number of sources of information.
These are hearing minutes. So essentially, the presenting officer prepares those minutes during the course of the hearing.
Yes. So we're not to see it like, as it were, a skeleton argument which has been made before the hearing and has been presented.
Yeah.
It's notes to self, which are then worked up as time goes on. But we're not concerned with the detail, but the particular what the particular part of the submissions that you're looking at is what, ground one?
Yeah, ground one. So you'll see my submissions below. Submissions, Ms. Arnold relied on the pleaded grounds where the point was made, and then she made all these submissions.
Yeah, but so, I mean, we don't know, and it doesn't matter exactly which of these she made and in which order and which she decided to deploy, but she certainly, if one looks at pages 55 and 56 and on to page 57, came very well prepared with arguments on this point, and one might assume that she deployed a good number of them.
Absolutely, including references to the case law, MA in particular, to which I've taken you to. So the impression that one gets from reading this decision is that the Secretary of State did not really put up a fight, which isn't a fair impression.
Yeah. In somewhat fairness to the judge, of course, this is being done on the basis of oral submissions.
Yes.
There's no indication of what his note consisted of, but it isn't a situation like we benefit from, of having not only you telling us what you're going to say, you then saying it, but also you telling us what you've told us after the event, because we still maintain your skeleton argument. The judge is dealing with it in a different procedural way.
And there's an issue here, isn't there, where delay can give rise to unfairness.
Yeah.
But this is a point on which the judge was either right or wrong.
Yes.
Yes.
And whatever may have been the position below, we now have your submissions, and we'll decide whether the judge was right or wrong. And we'll hear in a moment Miss Lanigan's submissions that no doubt she made to the judge as well, on the basis of which we can reach conclusions.
Absolutely.
Unlike, for instance, a hearing of where there are disputed issues of fact.
Yes, credibility in particular.
Yeah, and also in fairness to the judge, what he says is Ms. Ahmed could not say very much. He doesn't say did not say very much. I mean, it's an evaluation of the impact of the submissions made, isn't it, rather than saying she didn't say anything.
Yes, but the problem then is that, well, those submissions do not really feature at all in the judge's analysis. There's no reference to case law.
But that's your ground too.
That is my ground too. So in a case where there is a credibility finding, a ground like this will have greater force. But I hope the court knows the reasons why Secretary of State felt it appropriate to advance the appeal on this ground. But I agree completely that I'm either right or wrong on grounds 2, 3, and 4, and that would determine the outcome of the appeal. Unless I can assist you any further, these are my submissions.
No, thank you, Mr. Malik. Yes, Ms. Lanigan, you've been in this from the beginning.
I have, my lord.
Well, not from 2004.
No, sorry.
No.
I mean, this time round, yes.
Yes.
I mean,
Yes.
it's quite unusual in my experience to find somebody who's been there at the First-Tier Tribunal and finding their way through the Upper Tribunal and to this court. So well done.
Thank you, my lord. Well, I'll do my absolute best to assist you in this matter, given that experience that I have.
Yeah. Well, can I confirm what my lord said a moment ago, which is that in our discussions with Mr. Malik about what happens if,
Yes.
we are absolutely aware of the fact that we're just simply collecting everything that we need to know, and that eventuality may not happen. We're very interested to hear what your arguments are on all of these matters.
Yes. Would you like me to address that point at the outset,
Well,
in terms of disposal?
Well, if as it's fresh in our minds, if it's
Yes.
useful to you, by all means, please do.
Yes. My lord, I I think I'm bound to accept that it is open to you to remit to the Upper Tribunal as opposed to the First Tier. For what it's worth, I would invite you to remit the matter back to the First Tier. This is an appellant who, if you're not with me, and if you're with the Secretary of State, there have been errors in respect to the First Tier decision. I say it would be most appropriate to remit back for that reason. My Lords discussed a point in respect of the issue of the danger to the community, whether or not it's open to your Lordships to deal with that yourselves. I say that is an intensely fact-sensitive assessment. Yes, one might be able to consider certain contents of certain documents, but that is intensely fact-specific. It's an assessment, ultimately, of a witness, I say, against the background of the contents of those documents. And whilst, of course, your Lordships may well have regard to the probation letter that you've been referred to earlier, that is not going to be sufficient in my submission to deal with that point and to reach conclusions yourselves. I'm not sure whether that covers everything, my Lords. Is there something else in terms of disposal that you'd like me to address you on?
I don't think there is. No.
No.
Thank you.
Thank you. My Lords, you have my written submissions and my skeleton argument, which I don't seek to rehearse. What I intended to do was focus on the key points that I want to make in my oral submissions. The indication that you gave at the outset, my Lord, is really about grounds 2, 3 and 4. Whether you would like me to focus in that respect or deal briefly with ground 1, given
Well,
you've just heard submissions
I think maybe it's very unfortunate what's happened, and it happened that there was a long delay. I give you the opportunity to deal with what I was thinking myself about this, which was that sometimes a timely decision by the senior tribunal in dismissing an appeal from the First-Tier Tribunal might, in a sense, add strength to the First-Tier Tribunal's analysis because of some illumination that the later decision gives. I suspect that the consequence of delay may be that illumination is a good bit dimmer in this case, and that we are, after all, considering the First-Tier decision, essentially, not the Upper-Tier decision, although in form it's an appeal from them. And so I think if you want to say anything in relation to ground 1, in order to sustain and defend the content of the Upper-Tier decision, by all means do, but it may be that the consequence of delay means that somehow it's just more likely that we put that to one side and focus exclusively on the FTT.
My Lords, if it assists, the points that I make in respect to the Upper Tribunal decision lead into the points of ground 2, and it helps to illuminate the points that I make subsequently.
Right. So you don't need the upper tier for your defence of the First Tier, but to the extent that you want to call upon it, do as you go along, and we'll take stock about those matters.
I'm grateful. Also, before I begin, I do anticipate to be about an hour in total.
There's plenty of time.
Thank you. So, my Lords, if we start then with ground 2, and you have my submissions at paragraph 19 of my skeleton onwards, I'll say at the outset a question that my Lord Justice Dove raised in respect of what the test was for the parole board assessment. The test is that the parole board would only direct release if it is satisfied that it is no longer necessary for the protection of the public that the individual remains in prison. My Lords, you've been referred to the letter from probation. If it assists, then of course we can provide the the parole board's assessment itself, which will make that clear on the face of it. In this respect, ground 2, I want to emphasise 4 key points. The first being that in my submission, the judge applied the correct legal framework, and we can see that at page 80 of the core bundle. There's reference there, paragraphs 14 through to 18. We see in particular that the principles set out, which my learned friend has taken you through, Article 33.2, the rebuttable presumption under Section 72 at the bottom of page 80, and over the page, paragraph 18, the principles that are drawn from EN Serbia. We don't need to go there, you've already been taken there, my lords, but you will note, no doubt, that the content of paragraph 18 marries up with paragraphs 45 and 46 of EN Serbia, which you were taken to earlier. When one looks at the content of that paragraph and the principles in EN Serbia, that reinforces my point that I made earlier, my lords, that this is an intensely fact-specific, fact-sensitive assessment of whether or not an individual poses a real risk.
Is this your second point?
This is my first point still.
Oh, it's still the first point.
Yes. This is intensely fact-specific, and what I would term public interest considerations, namely, he should never have offended in the first place, don't come into that question. It's purely about danger posed to the community. Against that background, if we move to page 84, in my submission, the judge was plainly correct to consider that this was an isolated offence, and we see that at paragraphs 37, 38A, as well as 38B. Not only is it an isolated offence, there is no offending previously, so there is no, I think the term you used, my lord, was a career criminal. This is not that case. And furthermore, there is no further offending post-release. And in addition, there is ongoing fulsome engagement with the probation service, who has had the benefit of the monthly sessions and who has assessed him as presenting a low risk of committing a further offence and expected him to successfully reintegrate within the community. My lords queried the content of the probation letter and the specific link between medium risk and low risk of offending and how those two married up. I found the underlying letter. I don't know whether it would assist to read it out in full or just read the relevant section.
Well, if Mr. Malik's content, we're perfectly happy to after the hearing, to receive it electronically, so that we have it in our record, but by all means quote from it now, as we don't happen to have it in front of us.
Thank you, Miles. So this was the letter of the 7th of June 21.
7th of June 20.
Apologies, there was an updated one.
Well, we
22,
the ones,
I think, was the
Yes.
date.
25th April 22.
Yeah.
Correct. Apologies, my lords.
so you're not reading from the one at paragraph 34. You're looking at a different one, eh? I mean, I don't. We don't want to be drawn into, as it were.
I found the correct one.
The island hopping. We
Yes.
don't want to end up just looking at random documents
No, of
that
course
have
not.
arisen in discussion. So, which one are you in fact going to take us to?
The 25th of April 22.
Right. So we're firmly rooted in paragraph 34.
Correct.
Thank you.
And the paragraph from that, which you will in due course see, the specific terms are located in the second paragraph, which states as follows: Mr. D remains to be assessed as medium risk of harm to future partners based on his index offence. However, the assessed risk of reoffending is low. So rather than there being an overarching general point about low risk of any offences, this is specific in my submission to that question of reoffending in that way, in the way of causing medium harm to partners, which is the key point in his circumstances. I say the first-tier judge was absolutely entitled to consider that evidence, going as it did directly to the principles identified in EN Serbia in terms of risk of repetition. And she engaged with the legal framework correctly and correctly considered those factors.
Well, it said that against this background, even a low risk is a real risk. How do you respond to that?
My lord, the question of whether or not a low risk is a real risk is a matter for the judge based on the evidence. You've been taken to the case of MA Pakistan, which I will deal with in due course in a moment. But of course, it's dependent on the particular factors. It is absolutely right that the probation service in MA Pakistan acknowledged that the risk was, in their view, was low. The judge in that case considered that was sufficient.
But we've got to consider risk of what? I mean, if you have a chihuahua, a small poodle who occasionally snaps at children, that's one thing. But I mean, if you've got a pit bull terrier, or a Rottweiler who occasionally snaps at children, those are two completely different sorts of assessments of danger. I mean, I'm bound to say, intuitively, and I'm saying this so that you have an opportunity to make submissions about it, where the sort of risk that's being talked about is of harm that is catastrophic. In order to be satisfied that there's no real danger to the community, it's got to be practically no risk, doesn't it?
My lord, that's one approach. The point that I would make is that it is intensely fact-specific.
Yes,
because
but I mean, here we've got some intense facts.
Quite, and at first blush, and as the judge has repeatedly acknowledged, this is a serious offence, and I don't seek to persuade you otherwise. But this is a case in which it is an isolated incident. The trajectory of the work that has been done by KD, all of the evidence that was before that judge, notwithstanding the fact of the index offence, points towards positive reintegration into society, as demonstrated by what I say is powerful evidence from the probation letter that you will see in due course. His conduct in prison was exemplary. The parole board, did not consider it necessary for him to remain in prison for the protection of the public. And when one considers that this is a rebuttable presumption under Section 72, there has to be an ability, notwithstanding how serious an offence is, there has to be an ability for the individual to rebut that presumption.
You'll have heard the point I made earlier, which is that rebutting the presumption that you're dangerous simply because you got nowadays 15 months for false accounting may be one thing, but in a case of this sort, it's rather another thing, isn't it? I mean, the rebuttal has got to take account of what it is that you're rebutting.
Absolutely, and that brings me to my second point on this ground, where I say the judge was entirely aware of the seriousness of the offence, which necessarily is part of that Section 72(2) assessment, that second limb. The seriousness does come into it, but of course all the other factors are in play in terms of risk of repetition, rehabilitation, and so on. If I may take your lordships to specific references, and you will see the decision is strewn with repeat references or acknowledgements of how serious this offence was. So if I point your lordships to, firstly, page 83, paragraph 30, we have reference to the sentencing remarks, which of course indicate the nature and circumstances of the offence, including the level of violence involved. We then have at paragraph 31 again, specific reference and highlighting particular attention to the nature of that violence that was used. That's the penultimate line of that paragraph. And then 38A over the page, the judge acknowledges that key point, my lord, extremely serious offence. This is not a 2 years and that's that, it is extremely serious. And finally, over the page, paragraph 39, which is the wrapping up, concluding paragraph in respect of the presumption point. Notwithstanding the seriousness, she was satisfied that he had rebutted the presumption. So I say seriousness was at the very forefront of her mind throughout. Third point is that when we review paragraphs 33 through to 39 on these pages, in my submission, the judge took into account relevant factors, relevant evidence, and quite properly reached her own conclusion that the presumption had been rebutted. And I'd note just briefly at this point, this is a decision that the Secretary of State accepted at first blush was carefully reasoned, and that's in the notes at page 55. So even from the Secretary of State's perspective, that there is some force in my submission that this is a carefully reasoned decision. What's evident is that the judge at paragraph 34, page 84, is not simply blindly adopting the view of the probation service. She's not treating it as determinative. She's not slavishly following what someone else has said on paper, but she is carefully weighing up all of the evidence in the round before reaching her conclusions. And you see that specific phrase, carefully weighing up the evidence in the round, at paragraph 38. So there's no reason to think she's done anything else. I said I would bring your Lordship's attention to MA Pakistan, and in my submission, MA Pakistan doesn't particularly take this court very far. That was a case that, in my submission, endorsed a first-tier judge reaching their own conclusions as to risk. That's exactly what this judge has done. And in any event, the report in MA Pakistan appears to have been prepared for the purposes of criminal sentencing, as opposed to in KD's case, where the probation officer was specifically preparing a letter for the purposes of the tribunal, of the appeal hearing, some 4 years later. So on the facts, it can be distinguished anyway.
But the test in section 72 is danger, isn't it? Danger to the community. Is that simply about risk, or is it about risk and also allied to that the extent of harm? Because if you think about it in a criminal context, maybe, I don't know whether you have any experience of...
Very limited, my
very,
lord. Very limited indeed.
But when one is dealing with sentencing issues in a criminal context, there's always a relationship between culpability and harm. And here, I just wonder whether there's a relationship between risk and harm. So picking up the point my Lord Justice Peter Jackson made, if somebody's been convicted of a fraud offence and being given an 18-month sentence, one might take the view that the harm that individual might do is relatively limited in the equation of whether or not they're a danger to the community. Still got to get over the presumption, but that's one point. If somebody's committed rape or a homicide offence, well then the harm is significantly greater, isn't it? And So it's not just what's puzzling is it's not just about risk, but isn't it also about harm as well?
Absolutely, my lord, and I would acknowledge that. But if we look at paragraphs 33 to 34 of the decision, we see reference and grappling with that harm point as well as risk of reoffending point. So specifically, paragraph 33, there's a reference there to the parole board consideration of medium to high risk of serious harm. And just to remind your lordships, that was made in 2018.
Right, so paragraph 33 is the pre-sentence report, is that what we're talking about, or was the parole board? Sorry, 2018.
Yes.
The
Yes,
parole board was 2018. Yes.
So that's at the point of him finishing his minimum term.
Yes.
And considering that it is appropriate to release him into the community.
Right, so we have three stages. You say MA Pakistan was to do with the pre-sentence report.
I don't know that for certain, my lord, but certainly from the paragraph that's relied upon.
I was assuming it was because it said, perhaps more importantly, what may be an assessment of low risk for the purpose of criminal sentencing.
Exactly.
Is not necessary to be considered a low risk when looking at future behaviour.
Exactly.
So one might have something from the probation service pre-sentence.
Yes.
One might have something from the probation service on release.
Yes.
And one might have something from the parole board after release.
Exactly.
The parole board on release as well, if you're talking about release at a certain point during a sentence.
Exactly.
Okay, thank you. Now, sorry, your point about in this case the 2018 situation was what?
So we have an assessment at that point by the parole board.
Paragraph 33.
Paragraph 33, there's reference there to medium to high risk of serious harm to known adults, intimate partners. So you'll note in passing, I'm sure, this is not to the community at large, it is very specific circumstances. And then take that, at that point in time, compare that to what's seen at paragraph 34. The appellant is roughly halfway down the page. The appellant is assessed as posing a medium risk of harm. So the harm issue has been downgraded, as it were, over the passage of time, and in light of, I would suggest, the ongoing positive engagement.
Right, but what is meant in that paragraph by risk and harm? What is a medium risk of harm? What is that to do with the probability that something is going to happen? Is that all that's saying?
My lord, my reading of the letter, which again you'll see in due course, is that the medium risk part relates to the harm, whereas the low risk part links to the risk of reoffending, risk of repetition.
Well, it can't surely mean that if he does some harm, it's assessed to be medium type. Couldn't possibly reach such a conclusion because this is somebody who committed an appalling offence in the moment, according to the sentencing. So that wasn't medium and never will be. I hope we will be helped by the letter because I'm still in great difficulties with those two sentences that sit alongside each other and understanding what is meant. But it can't seriously mean that the harm of which we're concerned is harm of a medium sort.
Unless, my lord, the nature of the harm has changed over time as a result of the work that has been done, which I say KD.
Well, again, it can't possibly be reliable to say that he may beat people up but not kill them.
I'm not sure I can assist
take
any
it any
further,
no.
my lord.
All right.
I think I reached the end of my third point, but perhaps before I move on, you've heard points raised about remorse, the lack of remorse demonstrated by KD, and you have my submissions on paper in terms of my point, which is effectively they both amount to a state of contrition, This is not someone who, like in MA Pakistan, has disputed their guilt. He accepts what he has done. He is contrite, and that is relevant for the purposes of the assessment. But whether or not, my lords, you consider there is a material distinction to be drawn, when one looks at paragraph 38 at the bottom of page 84, you can see there the specific factors that led the judge to the conclusion that the presumption was rebutted, and you don't see any reference there to the remorse, regret issue. So I say it's immaterial.
Well, isn't that a point against you? Because what's said is that in considering matters in the round, the absence of proper remorse was something to be taken into account.
Well, my lord, the point that I would make earlier would be the one that I would rely upon in that regard, that effectively what matters is acceptance of responsibility and contrition. Whether or not it's phrased as regret or remorse is immaterial, and particularly when I did urge you to note this is an individual whose own words are interpreted by an interpreter. He's not expressing himself.
But it's difficult for us, and I completely take the point, and as far as I'm concerned, it's not the strongest point that's made in support of the appeal.
Okay.
But we don't really know what lies behind the first sentence of paragraph 35, which is that remorse, there is remorse, relevant, though not determinative, because obviously you will have had access to material which we don't have access to. So at the moment I have no idea what lies behind that assessment by the judge, and I think that if that was going to become an important part of our considerations, we'd need to have been shown a lot more than we've already been shown to understand why the judge thought that was the case.
My lord, yes, but of course you will no doubt be bearing in mind, and this brings me to my fourth and final point on this ground. This is a judge who's had the benefit of live evidence, cross-examination. I say she's entitled to reach the conclusions she did in respect of the appellant's.
Right. So we should assume this happened in a day, did it? This hearing.
It did, yes.
Right, but she had an opportunity to see your client in the witness box, and we are entitled to assume that if she said that he'd expressed remorse, that he'd expressed remorse. Is that how it works?
She's not required to set out to such granular detail the basis of her findings.
But sorry, can I just check the basis of this submission? Because at the moment I'm reading 32 to 39, and it all seems to be an objective assessment based on objective materials with no reference whatsoever to oral evidence from the appellant.
My lord, I take that point. What I have highlighted in my skeleton is that there was evidence in the witness statement dealing with, I would acknowledge regret, but this issue of contrition, that there was witness evidence in respect of that. So it's not purely about the documentation from the probation service or the parole board, for example. He did give evidence about it as well.
But the judge doesn't say in paragraph 35, I've heard the evidence from the appellant and I accept it. She finds the appellant's remorse to the crime is relevant, and she explains that by saying in the second sentence that she's had regard to the decision of the parole board and the expression of regret. So that seems to be the foundation, not acceptance of the appellant's evidence.
My lord, it may well be. What I would urge, what I would invite your lordships to do is adopt a very cautious approach indeed, because as we know from Ulla, for example, decisions are always capable of being better expressed. the reasoning by the judge can be set out explicitly and by inference. It would, in my submission, be an unrealistic burden to expect the judge to descend to that level of granular detail, particularly when one notes this is already a decision that ran to some 75 paragraphs. It would be unwise in my submission to adopt that level of scrutiny. I think, my lords, that brings me to the end of the points that I wanted to make on ground 2.
Well, is this a good moment then, and you can embark on? Are you happy to deal with 3 and 4 together in the same way?
I am. I had intended to make some overarching points and then a couple of specifics in due course.
But they're really, as it seems to me, 2 ways of
Yes.
looking at the same essential challenge.
My lord, yes.
All right. Well, thank you very much, and we'll start again at 2 o'clock.